Great, thank you, Liz. Hi, everybody, and welcome to Estate Planning for All Moms. We are here today to talk about the estate planning documents that are most necessary. And while you'll find that these are really the case for more than just moms, there's certain considerations for many mothers. And in honor of Mother's Day this Sunday, we just wanted to honor that and discuss it. So thank you again for joining us. And we'll get started on estate planning for moms. So, basic estate planning documents. So when we talk about estate planning for moms, for parents, we are talking about people of all different phases. So we could be talking about a new parent who has just had a brand new baby, maybe similar to this one that we have pictured here, who's actually a child of someone in our office. And we could be talking about a mom who has adult children, or we could be talking about the grandparent who is concerned not just about their child, but also about their grandchildren. We're talking about all different phases. And so when we look at these different documents that we're talking about having and it being necessary to have, you want to think about the fact that not just do you need them, you'll probably have to update them and redo them as you and your family go through these different stages. Obviously, a child that you have is as a baby is going to be a very different type of document, and you might provide for them very differently than you would if they were a teenager or a young adult or an older adult that maybe now has children of their own or maybe doesn't. And you want to take that into consideration. So in terms of your healthcare proxy, again, if you're a young parent, you are not going to obviously be naming your children to act as your healthcare proxy. So you're going to want to have a healthcare proxy put in place where you say who makes medical decisions for you if you cannot make them for yourself because you've been deemed incapacitated by a doctor. So this may be that you're doing this because you want to make sure that maybe during childbirth, if there's an issue where you have to go under sedation and decisions need to be made, you may want to make sure that whoever's there with you, be it a spouse, a friend, another family member, has the ability to make decisions on your behalf. Or this could be after childbirth where you're saying, well, should something happen to me going forward, this is who would make the decision. And then again, as you get older, you may now be in a position where your children are over the age of 18 and you want to name them to act on your behalf. Next is a living will. A living will is a document that says if you wish to be kept alive by certain artificial means, if there's no reasonable expectation of recovery. So here we're often talking about cardiopulmonary resuscitation, CPR. We're talking about dialysis, cancer treatments, whatever it may be. And you can state whether or not you would want those measures to be given to you if you were in this state that, as the doctor said, was beyond recovery. A HIPAA release is a healthcare information, I think we actually spelled it wrong here, but Portability Act. And we are talking about whether or not certain people can receive information about your medical condition. And a HIPAA release or a waiver waives your rights over privacy for your healthcare information and allows that information to be released by certain doctors to certain individuals. We're going to get into talking about power of attorney and last will and testament as well. So power of attorney is a document that says who can assist you with financial matters. And this is not just if you're incapacitated. So if I have a power of attorney and it names a person to act as my agent, that person can act on my behalf regardless of my capacity if I sign it in front of a notary and that individual signs it. And so a power of attorney document can really give a lot of control to another person, but it's duplicating the powers that I have for myself. And so I can do my own banking transactions, or my agent under power of attorney can do it for me. I could sign a contract on my own behalf, or my power of attorney could do it for me. A lease, a mortgage, life insurance, beneficiaries. And if the agent under power of attorney is given the right powers, they can make changes to beneficiary designations and change distributions on retirement accounts. Now, the power of attorney law says that the powers given to the agent have to be described in the document. So if somebody says to me, can a power of attorney do X? My response would be, well, let's look at the document and see if they have that power in the document. And if that power is not listed in that document, they don't have that. The new power of attorney law is that New York State the governor signed into law in December of 2020, a change to the New York State General Obligations Law. General Obligations Law is the law under which powers of attorney are created. So the law is actually what tells you what the rules are around the document, what form and substance the document has to take and have. And this new law is going to change quite a bit of things about the document. It is not in effect right now. It will be in effect on June 13th of 2021, which is a Sunday. But as of June 13th, if you're signing a power of attorney, you want to be signing with a document that's in accordance with the new law. But today, just today in my office, I signed a power of attorney with a client that was an existing client. We used the old law, and it is still an effective document, and it will be a valid document even beyond June 13th of 2021. So you don't have to worry that just because the law changed, you automatically need a new document. I'll give you a few scenarios in which I might suggest a new document to a client. I had another client who came in recently who had a power of attorney that we had done in our office several years ago. It was a perfectly valid document, but since that time, my client moved and therefore their address changed. One of their agents, the people they've named in the document, also moved, so their address changed. And now this new law is coming into effect. So for that client, we discussed that it might be a good idea for her to redo the document because 2 of the 3 people's addresses on the document are no longer the case. And therefore she may as well update it, and we're going to sign it after June 13th of 2021 to the new document. Now, if that same person had come in and she lived in the same place and her son lived in the same place, I probably would not have recommended an update to the document because the one she had was perfectly valid. And that is just going to be a case-by-case basis. So what I would say about this new power of attorney law, if we're talking about those moms who are those that have done this planning in the past, so maybe they're in their 20s, 30s, 40s, 50s, 60s, but at some point in the past, they've done that document. The question would be now, when you go back and see your attorney, you should say, I've seen that the power of attorney law has changed. Do I need a new document? And you can run through with your attorney all the reasons why it may be a good idea or a bad idea, or not necessary, I should say, for you to redo your document and make that decision. In terms of what is changing, the current document has what's called a statutory gifts rider that has to be signed and witnessed if the person that is signing the document wants their agent to be able to change beneficiary designations, change the way accounts are titled, transfer assets into a trust and out of the individual's name, to give gifts to charities, to give gifts to family members. And so if you're that grandparent that wants your agent under power of attorney to be able to give gifts to your grandchildren, you're going to need to have those powers. Now, the new law says that those powers still need to be listed and you still need to give the power to gift to your agent. But the difference is that it's not 2 separate documents. All of those powers are included now in the modification section of the current one power of attorney document. So whereas it was that you signed a power of attorney and then you signed the statutory gifts rider at the same time, you now just sign one document that includes all of the things. The idea there is that the legislature and the attorneys who advocated for it were trying to make the creation of a power of attorney a simpler and more streamlined process so people understand what they're doing and that we create less room for mistakes. Another thing that's changing that's really great for the disability community is that if somebody has a physical disability that has left them unable to sign the document, they can now direct another person to sign the document on their behalf. So if I have a physical disability and I cannot sign my name to the document, I can ask somebody else that's in the room with me at the time that I'm in the room to sign it on my behalf. There's certain procedure they have to follow and certain things they have to write, so it's clear that I asked somebody to sign it on my behalf. That person can't be the person I'm naming to act as my agent in the document. That person also can't be the witness or the notary. And so in that theory, I need to be in the room, the person that's signing for me needs to be in the room, the power of attorney, the notary needs to be in the room, and the witness. So you need at least 4 people in the room in that scenario. But that is going to be perfectly valid if I direct somebody to sign on my behalf. So for those that have physical disabilities, that's going to be a really big deal, as long as they have that mental ability to say, this is what I want to do. Another big change in the law, which isn't to the form and substance of the document, is that the banking or the institutions or any institution that you're asking to accept this power of attorney and to say, yes, this is a valid document and I will speak with or give information to or allow the agent to act on the principal's behalf, any entity that's accepting it is going to have very strict parameters as to how they can decide if they are accepting a document as valid or not, how they convey that information back to the person who's trying to get the power of attorney on file, and the process that should be followed. So what's going to happen is if I bring a power of attorney where I'm named as agent to a bank and I want the bank to put my name on the account as agent under power of attorney, the bank is going to only be able to reject my request and reject my document if it is under reasonable circumstances. So if they are being unreasonable, they can be held liable now, and they could be held liable for not just damages created by the delay in taking the document, but also for attorney's fees for bringing a proceeding. And so the hope is that institutions and those that are accepting power of attorney documents and reviewing them are going to be more fair in not just offhand saying this isn't a valid document because it's too old, because that's not actually what's written in the statute. If they do decide that they cannot accept a document, there's a set period of time by which they have to tell you they're not accepting it. I believe it's 10 days. You can then respond and say, well, here's an opinion letter of counsel, and my lawyer is saying it's valid, and this is the reason why, and it's all in the attorney opinion letter. And then they have 7 days to reply with a final answer as to whether they'll accept it or not. And again, if they don't accept it and you don't believe they're being reasonable, then you can actually reach out and start to a lawyer and start a proceeding. And if you win and the bank is told or the institution is told they need to accept that document, you can then ask for attorney's fees. And this, we call it, they're putting teeth in the law. This is really going to, we hope, make things a lot easier for an agent acting on someone's behalf. And we do have situations where moms come to us and they say, well, I was speaking with my child who's now 18 years old, and they're going away to school, they're going away to college, and they want me to be able to act on their behalf. Now that's flipping it a little bit, right? So instead of mom asking the child to their child to act as their power of attorney, This is the child saying, my mom can act as my power of attorney. And my mom, I am going to sign a document saying that she can access my bank account and speak to insurance companies on my behalf and all of these other things. And so as a parent, we have to think about often, what do we need for ourselves, but also how can we assist and support our children. And so having your children sign a power of attorney, and for that matter, a healthcare proxy and a living will in addition, can help the parent, if they have to act on the child's behalf, to have that authority. Because as we know, once you turn 18, mom doesn't have control over what's going on anymore in that child's life. They are now an adult, even though they'll always be mom's little baby. So next we'll talk about probate. So when we're talking about probate, we're really talking about last will and testament. So it's a very common misconception that if you have a last will and testament, you don't have probate. When in the end, they actually go hand in hand. You can't have one without the other. Probate, by definition, is the process of submitting a will to the court and asking the judge to validate that document and state that it is appropriate, that it's valid, that the wishes should be followed, and appointing the executor that's nominated under that document. That process requires that legal notice be given to your next of kin, whether they're included in the document or not, that your will is being probated. So let's take a mother who has one child. That one child is their next of kin. If the mother has a spouse and a child, the spouse and the child are both next of kin and are entitled to notice. If a mother lost their child, but now only has grandchildren, the grandchildren are the next of kin. Continues that way. If a child passes away and is not married and does not have children, but their parents are still living, well, then mom is next of kin, or dad is next of kin for the child that passed away. So the court looks at your genealogy, looks at your family tree, and determines who receives notice. And this is where people can come in and contest. So when we talk about, do I need to avoid probate, we're talking about, do I need to avoid this process because there's something in my situation that will make this unnecessarily lengthy and expensive? And that very often comes if you're disinheriting one of those natural heirs. It comes, so in my example, if mom has 2 children and she's disinheriting one of them, she would likely want to avoid probate because the one that she is disinheriting would get notice of probate, a copy of the will, see they were getting nothing, and may come in and contest. And so mom may want to avoid that process. You may also want to avoid probate if you don't know who your next of kin are. So if you're unmarried with no children, and your parents are deceased, you have no siblings, you're not sure where your aunts and uncles and cousins are, and you're not sure where your next of kin are, well, then you probably want to avoid probate because you want to avoid the need to search for and find those people to give notice. You also would want to avoid probate if you own property in multiple states. So if I have a client who lives in New York and that's their primary residence, they've got a little cabin up in Massachusetts and a condo down in Florida, well, then their will would have to be probated in all 3 of those states if that individual died without a joint owner on those assets, and you can't have a beneficiary on the deed. So it might be that you need to do a change to the deed, and we'll talk about how you avoid probate in a minute. But many people want to avoid those 3 different probate processes. What happens if I die without a will? So if you die without a will, it's actually a very similar process where we call it an administration instead of probate. Because again, probate means there's a will. Administration means that somebody died without a will. We call that intestacy. If you die intestate, you are dying without a last will and testament. Now, in addition, in administration, in addition to those next of kin family members getting notice, they also actually get your assets because you have not directed them to anywhere else. So that is where they default to. So if you've ever been lucky enough to have this happen or know somebody who has, every once in a while you hear about somebody who got a phone call that a long lost cousin passed away and that now all of a sudden you own half of a house. I recently had that happen in New York. I've had it happen in the past where somebody, without realizing it, was the next of kin to somebody who died without a will who owned property outside of the country. When that property was sold, that individual got money because through the administration process, they were notified that they were entitled to a portion of that estate based on how many people were the next of kin. And so that's what the administration process is. So you have to think through, do I want the assets to go to the default people, or is there some change I want to make? Does every will go through probate? So the only wills that go through probate are those of an individual that dies with assets in their sole name with no beneficiary. So if I have a retirement account that has a beneficiary named, and a checking account that's joint with my mother, and an apartment that I own on my own, and my will would be probated, but only for the purpose of passing on that apartment, because my bank account would go to my mother as joint owner, and my retirement account would go to the beneficiary named on my retirement account. But the co-op, let's say I own a co-op, the co-op wouldn't know who to turn the shares of the co-op over to. Or if I have a home, how does the deed go from my name to the next person if there's no legal process to determine who that appropriate person is? And that's what the probate or the administration process does. It dictates where the assets will go and who they will go to. So beneficiary designations, as I said, like on my IRA in my example, can be used to avoid probate, joint ownership of a property, or we can have assets be owned by a trust during our lifetime. When you're naming beneficiaries, this is a really important thing to look at. So let's say you have a bank account and you know who you want it to go to upon your death. You would name it as what we call a Totten Trust account, or you might have seen on your statement it says Britt Burner ITF and then another person's name. That means it's my account, but it's in trust for this other individual, and they receive it at my death by giving a death certificate over to the institution and getting that account. On a retirement account, we can name a designated beneficiary who would receive the asset on my death, again, by giving a death certificate and filling out certain forms. Same with life insurance, you can name a beneficiary. With retirement accounts and life insurance, we often see multiple beneficiaries be named. Perhaps you have 2 children and they're receiving 50-50, or 3 children and you've diluted it a little more. Those are important to name. Now, I want to point out that if you are a mother who has minor children, meaning children under the age of 18, or certainly if you have a disabled child of any age, you want to be very careful that you're not naming the beneficiary of a retirement account or a life insurance policy or a bank account to be that minor or disabled child. If you fall into that category, you want to make sure that your last will and testament, or if you've created a living trust during your lifetime, that it says that anything that goes to your child upon your death goes to them in a trust. Now, for a minor child, we'll often say that it will go into a lifetime trust, meaning it will be in trust for that child for their lifetime. But many times we can say, but at a certain age, that child can become their own trustee. And this is when we start asking the mother questions like, are you trying to protect your child from themselves or from others? Now, if you're trying to protect your child from themselves because you think that they're going to spend too much money, that they don't know how to handle money, you may never let them be their own trustee. You may name a different family member or a banking institution to be a corporate trustee. Or you may say, well, they wouldn't be very good at handling the assets now, but I think by the time they're 35, they could be trusted. And so you could say that it'll stay in trust, but they can manage it themselves at the age of 35. That's a decision that mom can make when deciding how to leave assets behind to her children. So many young mothers, especially, have retirement accounts. They have life insurance, and maybe that's all they have. Well, it's very important that they have a will that creates a proper trust for their child so that those monies can be paid into that trust. Because if you don't have a will and that life insurance or the retirement accounts are payable to a minor child, then that money sits in a non-interest bearing account and the child gets it outright at 18. And we don't want that. Certainly for a disabled child of any age, if they're on government benefits, beyond them maybe not being able to handle their financial affairs, this might be with some disabled children, there are many children who might have a disability that does not keep them from being able to manage their own accounts. But if they had control over it, they would lose certain government benefits that might provide housing or food or certain schooling. And so it's very important that you're mindful of what those benefits are and how to leave the assets to a trust. Now, if you go and you sign a last will and testament and you say, I'm creating a trust for the benefit of my minor child, it's very important that you take the next step of going back to those retirement accounts or those life insurance policies, and you actually change the beneficiaries to be the trust for the benefit of your child under your will. Because if you say that in your will that everything goes to your child in trust, but that life insurance beneficiary designation still has your child named individually, the trust will not be utilized because you didn't pay the proceeds into the trust. So it's very important that you not just create the estate planning documents, but then you go back to those accounts and you tie in the beneficiary designation. With 529 and college plans, we often see where mom may have a plan for their child and maybe grandma has one as well. Well, if grandma has one and grandma passes away and there's money left in the account, have we named the successor owner of that account? Because we don't want to pay the money out to the child. Perhaps they haven't gone to school yet and there's tax benefits to paying directly to the educational institution. And so you want to think about the fact that for those 529 plans, that you have a successor owner. And you also want to think about who the successor owner should be and speak with a professional. If grandma has an account for grandchild, you might not want to make mom the successor owner because it may impact the amount of financial aid that the child can get. And so you want to be mindful when doing that and naming the successor owner that if something does happen to grandma, that the child can still get the most amount of aid possible. So I talked a little bit about trusts already, and I'm going to talk a little more now. So there are different types of trusts. So a trust, just for definition, is as written here. It's a document. It's a legal entity. So if I create a trust, I am the grantor. I set the terms of the trust. And depending on how I set the terms, dictates what type of trust it is. If I have all the control during my lifetime and I can do whatever I want and I can get as much out of the trust as I want and I can give it to whoever I want, then I'm probably creating a revocable trust. Whereas if I'm putting limitations on how I can receive income, how I can receive principal, how others can, if I'm limiting my own control over that trust, I'm probably creating some type of irrevocable trust. But there's many different types. And so what we need to do is sit down and really talk about what is the purpose of creating the trust. Sometimes people come in and say, I need a trust, and that's the end of the conversation. Whereas it should be that we get to that point after discussing, what are your goals? What are you trying to do here? What do you want to happen with your money? What are you trying to protect from? Who are your beneficiaries? And once we talk all that through, we can start to shape whether or not somebody needs a trust and what type of trust that might be. And so we're always looking at the purpose and the goals to drive whatever plan we come up with. A lot of people come in and say we need a family trust. Now, a trust name may have some information about what type of trust it is, but quite often the term family trust, for example, could be used for many different things. It could be used for revocable trust that I create, which in my head, I'm creating for my family to leave behind to them. It could mean a trust created by one spouse for another spouse in their last will and testament or trust. So there's that term of the trust or the title of the trust does not hold any meaning for what type of trust it is. And so when we come up with the name of a trust, we try to put into the title to be somewhat specific, to give some clues as to what type of trust it is. But in the end, it really all comes down to looking at the trust document and saying it's X type of trust because these are the provisions that are included. So again, when we talk about revocable versus irrevocable, many people talk about a living trust. Well, a living trust just means that that's a trust that I create while I'm living, as opposed to a testamentary trust, which is created by my mother through her last will and testament, and she leaves it behind to me. That's a testamentary trust, where the living trust, again, is one that I create for myself while I'm alive. The descendants trust, and this is a term that we use, but again, it's just how we identify a trust that is left behind for a descendant. It could be a beneficiaries trust, it could be an inheritors trust, and again, the exact type of trust it is going to depend on what terms I put into that trust document. Insurance trusts are often trusts that are created to hold a life insurance policy, so that upon the death of the creator of that trust, who's usually the insured on the policy, the proceeds of the policy, the death benefit, is not included in the taxable estate of the person that died. So insurance trusts are often used as a tax planning tool to move assets out of the person's name so that their family members pay less estate tax upon their death. So I'm going to stop now and take questions. So thank you everyone for joining. We have a Q&A box at the bottom of the screen or wherever it is, depending on what type of tablet you're on, where feel free to put in questions. I just want to add that what we are doing when we talk about creating trusts and how moms create trusts is just a matter of being mindful of who mom wants to leave things to, how she wants to leave them, who she's looking to protect, who she wants to protect them from, and the best way to accomplish those goals. So thank you everyone for joining us. I'm not seeing any questions. I hope that you all have a wonderful Mother's Day and a wonderful weekend, and we'll talk to you soon.